there's a fucking white lady that's trying to fucking trademark every part of Mexicans ain't.
Do not stress, you have nothing to worry about. My sources are literally, trust me, I'm a lawyer. Camelia, I'm a trademark attorney here at Imani Law. This video is not legal advice. I'm gonna break down exactly why you should not stress about this at all. Totally understand people see a trademark is filed and then they freak out. Filing a trademark application is not the same as having a registered trademark. This person filed the application 2 days ago. Trademark registration process takes at least 12 to 16 months, and that this trademark has not passed through the registration phase. Therefore, the person that filed does not have rights to this brand. Now let's talk about the law in the United States. Trademarks in the United States are based on a first in use and not first to file basis. Yes, maybe this person filed it before you, but when you go to the application itself, you can see this person filed it as a Section 1B basis, admitting that they are not using this mark yet in commerce and they plan to in the future. So yes, even though this person filed it before you did, you can prove that you were the first to use this mark. You can always oppose a trademark applicant's trademark, that the mark does not pass through registration. The other thing is that this person filed it in Class 25 for t-shirts. There is a very high bar to getting your mark registered. It's a whole separate conversation on what this person needs to do in order for their mark to even pass through the registration phase, because there's a lot. Just to make this concise, I also want to explain that just because somebody trademarks something in the t-shirt class does not mean that they have a monopoly on that phrase. For example, if this person just puts Mexicans aren't going anywhere on the t-shirt, their trademark application is going to get rejected. Anybody can put anything on a shirt. Phrases on a shirt are merely ornamental. This person filed in Class 25 saying that their brand is Mexicans aren't going anywhere, and their brand sells t-shirts. Again, I'm not even saying this mark is going to get registered. That is going to take a lot of analysis, and I'm happy to do a separate video, but there's a lot in there. I just wanted to make the second point to say that it's not like somebody's going to have a monopoly on that phrase. So this person didn't file for anything else besides t-shirts. Like you could create a chocolate brand and call it Mexicans aren't going anywhere. Unrelated goods. No, there's no monopoly on this phrase. No, the person who filed this does not own it. Yes, if you can prove that you were first to use this mark in commerce, in this case, you would be saying, yeah, I was using it first for t-shirts because that's what she filed for. And you can oppose her application because she filed as a 1B, saying that, hey, I'm actually not using this mark yet, but I plan to in the future. She just filed yesterday, meaning that a trademark examiner isn't even going to get assigned to her file for another 6 months at least. Then when she does get assigned to a trademark examiner, she's going to have to show that Mexicans aren't going anywhere is her brand and not simply a phrase she's just putting on t-shirts. And then there are a bunch of steps after that. She's still also going to have to prove that her mark is not confusingly similar to any marks that are before her in the trademark database, as well as all the other issues that come up with the trademark registration process. And in that time, who knows, she might even abandon this application because yes, right now this is trendy. All this to say, you don't have to worry about it. When you do have a brand that's really important to you, this is why it's really important to start the trademarking process right away, because it's always going to cost a lot more money, a lot more time, and a lot more energy to go through these types of situations and oppose trademark applications, as opposed to from the very beginning filing that trademark application. There's so much more I want to add, but with stitched videos, it's really hard to see what you've already said, what you haven't, and then edit. I'll post this and see if I missed anything. But the TLDR is, you don't have to worry. She does not own this brand yet. If you were first in use, then you can always oppose the mark. And anybody can file a trademark application. The trademark office would love to just take your money. But legally, you do not have rights to a brand until you have that registration certificate, which right now in the United States takes at least 12 to 16 months. And that is if there's nothing wrong with your application. Most of the time there is with most applications that are done without an attorney. Trust me, I file trademarks for my clients every single day, so I have seen it all. Always, I hope this was helpful, and feel free to follow for more tips.